that as the all clear. Recording in progress. Everyone is here and we just received the message to get started. Let's call the case officially of Marks versus Sonny's Rooftop Bar. My name is Judge Ramsey. Scoring judges, please look to the two buttons on the lower left of your screen and turn off both your audio and video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means the only people on screen right now should be both the advocates, Mr. Long and Miss Beatty, as well as myself. Can you guys both make your appearances? Let's start with the people.
Good evening, Your Honor. My name is Henry Long, and I'll be representing the plaintiff in today's case, Ethel Marks, the mother of the decedent, Jessica Marks. Today, I'm joined by my co-counsel, Mr. Mutavignesh Meenakshasundram.
Good afternoon, Your Honor.
Good afternoon. And for the defense?
Yes, Your Honor. Hello, Your Honor. My name is Lillian Beatty, here on behalf of the defense, Sonny's Rooftop Bar, and I'm joined today by my second chair, Miss Madeline Beatty.
All right. Before we move on to opening statements, is there anything that either party needs to address with the court?
Yes, Your Honor, the plaintiff has a few pretrial matters.
Go ahead.
Your Honor, I'd like to begin by apologizing for my voice. I'm recovering from a cold right now, so that's why it sounds a little bit scratchy.
Thank you. No apologies necessary.
And then I just have a few questions, seeing as this is our first time in your virtual courtroom. When we're sharing exhibits and demonstratives, would you like us to ask permission before putting them up on the screen or just announce what we're doing?
Please ask.
Yes, Your Honor. And should we assume that when exhibits are posted onto the screen, they're constructively outside of the presence of the jury until we enter them into evidence?
Yes.
And then lastly, we'd like to ask permission to use Exhibit 2 in our opening statements, a photo of Jessica Marks. We'll be entering this into evidence shortly after we begin our direct examination.
Any objection?
No objection, Your Honor.
So granted. Anything else from the plaintiff?
No, Your Honor. With that, the plaintiff is ready to proceed to opening statements.
Does the defense have anything to address before we begin?
One pretrial matter, if I may, Your Honor.
You may.
Yes, Your Honor. We would simply like this court to take note of evidentiary ruling 11 that states that exhibits 1, 22, and 23 are pre-admitted into evidence and may be used at any time throughout the course of today's trial.
Can you give me those numbers one more time?
Yes, Your Honor. Exhibits number 1, 22, and 23 per evidentiary ruling 11.
Anything additional?
No, Your Honor. At this time, the defense is ready to proceed to opening statements.
All right. We will now proceed with opening statements from each party. Everyone should make sure that they are currently in speaker view in the virtual courtroom. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Plaintiff, when you're ready.
Yes, Your Honor. Just a moment while I get ready.
No rush.
May I proceed?
You may.
Members of the jury, the defendant saw the signs, but they just kept serving. This is Jessica Marks. She's a young college student, full of life and with a bright future. Ms. Marks, in March of 2019, she took a spring break trip right here in LA to visit her best friend, Morgan Levitt. Around 9 p.m. on the final night of the trip, the two went over to Sonny's Rooftop Bar in LA. Just 3 hours later, Ms. Marks was found dead at the bottom of a ravine. And today you'll hear that Miss Marks' life was cut short because the defendant, Sonny's Rooftop Bar, served this 19-year-old girl, this 5 foot tall, 115-pound girl, till she could barely walk. Let her stumble out the door and get behind the wheel. Miss Marks only made it 1,000 feet out of the parking lot before her car veered off the road and she died. Now, we, the plaintiff, have brought a wrongful death case against Sonny's Rooftop Bar under the California Dram Shop Act. This means that we need to prove two things to you more likely than not. First, that the defendant gave alcohol to Miss Marks when she was obviously intoxicated. And second, that this over-serving was a substantial factor in her death. Now, today, you're going to hear the phrase obviously intoxicated quite a bit. Put simply, it means that when the defendant served Miss Marks, a reasonable person like you and me could tell that she was drunk. So listen closely today for evidence of Miss Marks slurring her words, losing her balance, having red eyes, or impaired judgment. And pay special attention to the fact that the defendant, Sonny's Rooftop Bar, saw those signs, but they just kept serving. Now, to get a better idea of what happened on the night of March 24th, you're going to hear from Miss Marks' best friend, Morgan Levin. Mr. Levin's going to tell you that Miss Marks was looking and acting drunk the whole night. Mr. Levin will even tell you about a particular instance when Miss Marks was so impaired that she stumbled down the stairs and fell right into the arms of the bar's owner, who turned to their bartender, laughed, and said, "We might need to cut this one off." But instead of cutting her off, they kept him coming. They saw the signs, but they just kept serving. Now, in a moment, Miss Beatty's going to get up here before you. And she's going to try and blame a dead 19-year-old girl instead of acknowledging the role that her client played in this tragedy. Members of the jury, the employees at Sonny's Rooftop Bar saw the signs, but they just kept serving. That's why today, at the end of today's trial, I'm going to come before you and I'm going to ask you to find Sonny's Rooftop Bar liable for wrongful death.
All right, thank you, Mr. Long. We're going to switch over to the defense. Ms. Beatty, do you need a moment or are you ready?
I'm ready to proceed, Your Honor.
At your leisure.
Thank you, Your Honor. May it please the court. She didn't have to drink. She didn't have to drive. She had other options, but she didn't take them. Ladies and gentlemen of the jury, today, the plaintiff has told you a tragic story. The story of a 19-year-old girl who went to a bar, who ordered drinks, who became intoxicated, and who ultimately passed away in a car crash. But what they didn't tell you was the real reason for that car accident. Simply put, Jessica Marks didn't have to drink. She didn't have to drive. And she chose to ignore the other options that she was presented with. Because it wasn't any action or inaction on behalf of my client, Sonny's Rooftop Bar, that caused Jessica Marks' death, but rather her own actions that led to her passing. Today, members of the jury, the plaintiff must prove to you by a preponderance of the evidence that Sonny's Rooftop Bar is responsible for Jessica Marks' death, that their action or inaction was the proximate cause, a factor so substantial that you believe it to be the most likely reason for Jessica Marks' death. The plaintiff must prove that the employees working at Sunny's rooftop bar first knew that Miss Marks was underage, that she was a minor, that they continued serving her alcohol past a point of obvious intoxication, that they should have known she was obviously intoxicated, and that they should have stopped serving her. In response, we have asserted what's called an affirmative defense of comparative negligence, which simply means that if we show that ultimately it was Miss Marks who made the series of decisions that led to her passing, that you should find the defendant not liable. Today, you'll learn that Mr. Levin and Miss Marks arrived at Sunny's at around 9 p.m. Then you'll hear that while they'd been together during the week of March 24th, Morgan Levin, Miss Marks's best friend, cannot attest to her alcohol or drinking habits for almost a year prior to her death. In fact, you'll learn today that Mr. Levin was surprised at the very end of the night that Miss Marks wasn't as intoxicated as he would have thought. You'll hear from both Morgan Levin and Sunny Maida, the owner of Sunny's Bar, that on March 24th, 2019, the defendant only interacted with Miss Marks and Mr. Levin for 10 minutes at most out of the 2.5 hours that they were there. And today, the plaintiff has come before you and said that Sunny's rooftop bar saw the signs, but they just kept serving. However, you'll hear that over the course of the night, Sunny Maida didn't notice any signs of obvious intoxication over the mere 10 minutes that they were able to interact with Miss Marks. And ultimately, you'll learn that at the end of the evening, it was Miss Marks who made the decision to pull out her keys and to drive. And you'll learn that there was an Uber waiting outside the bar for her. And if she had simply taken that Uber, we wouldn't be in court here today. Members of the jury, it's no question that the death of Jessica Marks is a tragedy. However, the reason for that tragedy can be boiled down to one simple decision. She didn't have to drink, and she didn't have to drive. It's because Jessica Marks ignored the safer options and made those decisions, we ask you find the defendant not liable. Thank you.
All right. Before the plaintiff moves on to its first witness, I want to ask everyone to switch into gallery view. That button again is on the upper right corner of your screen. This should allow you to see the attorneys and the witnesses at the same time. Mr. Long, when you're ready, we'll proceed with the plaintiff's witness.
Yes, Your Honor. Just a moment while I orient my camera.
You may.
Your Honor, at this time, the plaintiff calls Morgan Levin to the stand.
All right.
May I proceed?
You may.
Please introduce yourself to the members of the jury.
Hi, my name is Morgan Levin.
What do you do for a living, Mr. Levin?
Actually, I don't work. I'm a student at UCLA.
And do you know Jessica Marks?
I did. She was my best friend.
Your Honor, permission for my co-counsel to put a copy of Exhibit 2 up onto the screen.
Any objections?
No
You may.
objection.
Who's that in the picture?
That's Jess.
And when was this picture taken?
I think it was taken at our high school graduation.
Your Honor, at this time, the plaintiff offers Exhibit 2 into evidence.
Any objections?
Without objection, Your Honor.
So entered.
Now, when was the last time you saw Miss Marks?
I last saw her on March 24th, 2019.
Now, what happened on March 24th, 2019?
Well, Jess was in town over spring break. She was visiting me, And that night we wanted to celebrate, so we went out to a bar,
What bar did you go to?
Sonny's Rooftop Bar.
Did you do anything before you went to the bar?
Yeah, like I said, I went over to her Airbnb and we talked. We had a couple drinks.
How many drinks did Jessica have before she got to the bar?
I think she had one glass of wine.
And what time did you guys get to the bar?
Gosh, it was a long time ago, but I think 9.
How was Jessica looking after just having that one drink?
She seemed a little drunk, to be honest.
How could you tell?
Well, she had bloodshot eyes. She was slurring her words. She smelled like alcohol, things like that.
Permission for my co-counsel to put a demonstrative up onto the screen.
You may.
Permission for, now, Mr. Levin, you said you arrived at the bar at 9 p.m. Let's talk about what happened when you were at the bar. Did you have any drinks at the bar?
I did.
Would you recognize photos you took of the drinks at the bar that night?
I would.
Showing the witness exhibits 10 through 16. Could you identify these exhibits for us?
Sure. So Exhibit 10 looks like a video that I took, and then the rest are photographs I took.
Zooming in more closely on exhibit 10 and showing a sped up version of it, how does exhibit 10 look? Does it look like a fair and accurate copy?
Yeah, that's the video I took.
Your Honor, at this time, the plaintiff offers exhibits 10 through 16 into evidence constructively outside the view of the jury.
Any objections?
We would object to Exhibit 10, Your Honor, on the grounds of hearsay. May I be heard?
You may.
Your Honor, we would specifically object to the nonverbal assertions and conduct of Ms. Marks within Exhibit 10.
Are there any audio on Exhibit 10?
Yes, Your Honor, there is audio attached to exhibit 10.
Are you intending to enter in any of those statements then? We
Yes,
just
Your
paused.
Honor. Yes, Your Honor, but these statements are admissible under 801 D2A, admission by party opponent. Ms. Marks is the plaintiff. The Marks family is the plaintiff in this case, and therefore statements made by Ms. Marks are admissible under that rule.
Defense?
Your Honor, we would specifically assert in regards to any statements, nonverbal conduct being made within this video as being more prejudicial than probative in that case.
I'm going to allow it for now until I hear what the statements are. You're free to renew the objection once they're come in.
Yes, Your Honor.
Now, Mr. Levin, how many drinks did you have that night?
I had one glass of wine, one beer, and one shot.
And to the best of your knowledge, who had the rest of the drinks in the picture you took?
Jessica did.
Let's talk more about the drinks she had. If my co-counsel would bring up the pictures of exhibits 12 and 13. When those photos were taken, what had Jessica drunk by that point?
Well, I had the one glass of wine, but she had the rest of the bottle. I think she also finished off a beer.
Now, after she had those drinks, do you remember any interactions you had with the employees at Sonny's Rooftop Bar?
Yeah, there was one time where we went to use the restroom, and she's having trouble walking, and just like slipped and fell on the stairs right into the bartenders.
And how did the bartenders react when she slipped and fell right into them?
Well, Sonny Mehta, who was our server, just said, "We might need to cut this one off."
After Ms. Mehta said, "We might need to cut this one off," did they stop serving her?
No, I mean, that was around 10 p.m. We were there for a couple more hours.
Well, let's take a look at some of the other drinks she had that night. If my co-counsel would bring up exhibits 10, 14, 15, and 16 with their stipulated timestamps. By the time these pictures were taken, what had Jessica drunk at that point?
I think she had a beer, 3 White Claws, and 2 rum and cokes.
And after she had these drinks, do you remember any other interactions you had with the bartenders that night?
Yeah, around 11:45 when we were about to leave, I remember Sonny, he came up to our table to clear off the drinks, and she just said, "I hope this one's not driving." And she pointed to Jessica.
After Sonny Mehta said, "I hope this one's not driving," did they stop serving her drinks?
No, they served us each a shot.
So looking at all the drinks that Miss Marks had that night, does that up on the screen accurately represent all the drinks that Miss Marks had on the night of March 24th, 2019?
It does, yeah.
Mr. Levin, what happened after the defendant served all these drinks to Miss Marks?
Well, after we left, I got into an Uber. Jess, she got into her car, and she didn't make it more than 1,000 feet away from the bar before she crashed.
Did Jessica survive the crash?
No, she didn't.
Thank you, Mr. Levin. No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor, but before I begin my cross-examination, I wanted to make a clarification as to exhibit number 10, as it was never played for the court. Does my objection still stand?
That's a great question. Let me ask Mr. Long, you never actually played the contents of Exhibit 10 in its entirety, only the sped up version. Is it your intent for the jurors to be able to see the entirety of Exhibit 10 or to only see the sped up version that was previously played?
Your Honor, it is our intent to show the entirety of Exhibit 10, but we will be doing that on cross-examination of the representative of the defendant.
At this time, then, based on what's been entered so far, I'm only going to allow the jurors to see what has been shown, the sped up version. If during a cross-examination you would like to expand what the jurors can see, I'll need to see that foundation there and renew the defense objections to that. So at this point, all that's been admitted is what has been played to the jury.
Of course, Your Honor.
Yes, Your Honor.
And thank you for your clarification, Ms. Beatty. You may proceed at your leisure.
Yes, Your Honor, thank you. Firstly, Mr. Levin, I just want to say I'm very sorry for your loss and make sure to get you out of here quickly. I just have to ask you a couple of questions. Would that be all right?
Yeah, that's fine.
So I want to start off by talking about your experience with Jessica's use of alcohol. You two grew up together, is that correct?
Yeah, we knew each other since we were kids.
And you remained close throughout high school, right?
We were best friends.
Well, you stated that you first saw her drink alcohol during your junior year of high school. Is that true?
I think that sounds right.
And so that means that you had experience with her drinking during your junior year, or at least a portion of it. Is that right?
Yeah.
And you also had experience with her drinking during your senior year, correct?
Yes, ma'am.
But for clarification, Mr. Levin, you did part ways for college. Is that right?
Yeah, I went to UCLA. She stayed in Philly.
So after high school in 2018, you didn't see each other as frequently. Is that right?
No, we didn't.
And you have no idea how much she drank in college, right?
No, I don't.
Or how often?
No.
Or what kind of alcohol she consumed while she was in college?
I mean, we rarely saw each other.
But you would agree with me that when you first saw Jessica over winter break of your freshman year of college, you did notice that she was drinking more than she had in high school, right?
Seemed like-
Objection, character evidence.
Ms. Beatty?
Yes, Your Honor. We're not necessarily using this to prove that Miss Marks was conforming with a character trait of drinking more than she had in high school, but rather to prove that Mr. Levin can't necessarily testify as to her drinking habits for almost a year prior to her accident.
I'm going to allow it as it's currently phrased and has the line has been going so far. If it gets any further, Mr. Long, you may renew that objection.
Yes, Your Honor.
Yes, Your Honor. Now, I'll go ahead and re-ask that question. You would agree that over winter break of your freshman year, you noticed that Jessica was drinking more than she had in high school, correct?
Seemed like she was, yeah.
In fact, she even surprised you with a fake ID so that you could both purchase alcohol. Is that true?
She did.
And after winter break, the next time that you saw Jessica was March of 2019, right?
Yeah,
Which was during spring break.
that's right.
And during spring break, you and Jessica used your fake IDs at a couple of different locations.
Yes, ma'am.
And of course, this included
Objection substantially more prejudicial than probative.
Explain.
Your Honor, the probative value of this line of questioning, specifically going to the fact that Ms. Marks and Mr. Levin did use fake IDs, specifically goes to show how they were able to obtain alcohol in the first place and the reason that we're here in court today. The probative value substantially outweighs any prejudicial effect it could have on the jury.
Mr. Long?
Your Honor, both parties have stipulated that at the time they were served, Miss Marks and Mr. Levin were minors. It's not an issue in contention today about whether they were minors when they served. Therefore, showing that Mr. Levin used a fake ID is substantially more prejudicial against Mr. Levin than it is probative to show any fact that hasn't already been stipulated.
Your Honor, if I may be.
You may.
Thank you, Your Honor. We're not intending this evidence to show that Mr. Levin is untruthful in his character, but rather it just serves as foundation for the reason that the two minors were able to obtain alcohol in the first place. As opposing counsel stated, this isn't necessarily an issue, but it does go to show how these events occurred.
I'm going to allow it in for now.
Yes,
Overruled.
Thank you. I'll go ahead and re-ask that question for you, Mr. Levin. Now, you did, with Jessica, use your IDs multiple times. Is that true?
I'm not proud of it, but we did.
Of course, and this did include Sunny's Bar, which was how you were able to obtain alcohol.
Yes, ma'am.
So I want to talk a little bit about that night at Sunny's Bar and give the jury an idea of everything that was going on. When you first arrived at Sunny's, you and Jessica sat on the rooftop, right?
We did.
And you would agree that there were around 10 or 12 other customers.
I think that sounds about right.
And it was relatively dark out.
It was not.
And you would agree that you got to Sunny's at around 9 p.m. that evening.
Yes, ma'am.
And you left at around 11:45.
That's right.
So to be clear, that's 2 hours and 45 minutes in total that you spent at the bar.
Yes, ma'am.
And so if we do the math, that's about 165 minutes at the bar, right?
That sounds about right. I'll take your word for it.
Of course. Now, during your time at the bar, you were served on the 24th by Sunny Maida, who you know is the bar's owner.
That's right.
And you interacted with them around 8 to 10 times on that evening, right?
Yes, ma'am.
And those interactions never lasted for longer than a minute, right?
I don't think so, no.
Well, yeah. So just to be clear for the jury, it was about 30 seconds to a minute every time you interacted with them. Is that true?
That sounds right.
So out of the 165 minutes that you and Jessica were at Sunny's, only 8 to 10 minutes at most were spent interacting with Sunny Maida.
I mean, I couldn't tell you the exact amount of time. I just know that she was coming up to take our drinks and then give us more.
Now, Mr. Levin, you would agree that out of everyone at Sunny's that night, you were the closest to Jessica Marks.
It was, of course.
And you were with her for nearly all of the 165 minutes that you were at the bar.
Yeah, we were sitting right next to each other.
And even you would agree that she didn't seem as intoxicated as you would have expected, right?
I'm not sure what you mean.
Just to be clear, you stated in your deposition that Jessica didn't seem as drunk. as-
Objection, hearsay.
Defense?
Your Honor, I'm simply asking this witness to clarify something that he stated prior.
I'm going to sustain the objection.
Yes, Your Honor. Well, let's go ahead and talk then, Mr. Levin, about how you and Jessica left the bar that night. You
Okay.
left it around 11:45, correct?
Yeah, we did.
And no one came outside with you and Jessica, did they?
No, it was just us.
And you had called an Uber for yourself, right?
I had.
And you encouraged Miss Marks to take the Uber with you, right?
I did.
And she said she was fine, didn't she?
That's what she said.
She even joked around and gave herself a sobriety test, right?
Yeah.
To be clear, Mr. Levin, Jessica Marks could have taken that Uber with you,
I mean, yes.
but she chose not to.
I don't really think she was in the right state to choose anything, but she did.
But just to be clear, Jessica drove home that night, or at least attempted to.
She did. Yeah.
Thank you. And again, I'm sorry for your loss. Thank you for answering questions today. Your Honor, nothing further at this time.
Is there any redirect examination at this time?
No redirect, Your Honor. At this time, the plaintiff rests its case in chief.
All right. We will move on to the defense case. Do we need to take a break at any moment, or can we keep going?
Your Honor, granted that everyone else is ready to proceed, we are.
All right.
The plaintiff
then
is
let's-
also ready.
All right, then let's go ahead and move forward. Ms. Beatty, when you're ready.
Yes, Your Honor. At this time, the defense calls Sunny Maida to the stand. And Your Honor, may I proceed?
Yes, when you're ready.
Thank you. Good afternoon, Ms. Maida. Would you go ahead and introduce yourself to the jury for me?
Yes, my name is Sunny Mehta. I'm 27 years old. I'm a business owner and entrepreneur.
Do you currently own a business?
Well, I do until September 1st. That's when Stepkins takes ownership of Sunny's Rooftop Bar, the name of my business.
Well, why is someone else taking ownership of your bar?
Well, back in 2019, the state cited us for serving alcohol to minors and rescinded our liquor license. I had to shut down.
And for clarification, did that citation have anything to do with the death of the plaintiff, Jessica Marks?
Yes, it was in direct response to Sunny serving Jessica Marks alcohol as a minor.
Now, before we get into that service, the events of March 24th, I want to talk about some of the protocols that Sunny's followed while you were still operating. Are there any certifications or standards that you're required to follow as a business?
Yes, there's a code that businesses have to follow. And as a business that serves alcohol, we have even more rules. We have to have a liquor license, and our bartenders are individually certified to serve alcohol.
Are there any protocols in regards to age verification?
We have ID scanners, but those don't always work perfectly, which is why of our bartenders know what to look for when checking an ID.
And would you be responsible for training your bartenders in regards to age verification?
To a certain degree, I instruct all my employees to card anyone who looks younger than 45.
And are there any protocols in regards to identifying when someone's intoxicated?
Yes, the state of California requires that any business that serves alcohol on the premises has to complete a state-approved course and pass the certification.
And what information and instruction, at least to your knowledge, does this course include?
We have to know when someone is intoxicated. We have to notice the signs of intoxication, how to recognize when a person is intoxicated, and how alcohol impacts the body.
And to be clear for the jury today, how many of your employees took this course?
Every single one of them.
And how many passed?
Objection, lack of foundation.
Sustained.
For clarification, did you ever ask your employees if they had completed this course?
Yes, and they all told me that they did, and they passed.
Objection, hearsay.
Sustained.
Now, I want to ask you personally, have you taken this course?
Yes, I have.
And have you passed the final exam?
Yes, I have. I have my certification.
Now, before we talk about March 24th, would you mind explaining for the jury how your bar is set up?
Well, we have 2 floors. The top one is where we have our seating for our customers. The bottom one is where we have the actual bar to make the drinks.
And on March 24th, how many people were working at Sunny's?
Only me and Frankfurt Johnson, one of my bartenders. It was a Sunday night in March, so we weren't expecting a lot of customers.
Do you recall when you first saw Jessica Marks on that night?
I first saw her when she arrived with her friend Morgan around 9 p.m.
Did she sit at the bar?
No, she and her friend Morgan were up on the roof sitting at table 4.
And how many customers would you estimate were on the roof at that time?
Between 9 and 11:45, there were around 20 people total, never more than 12 or 14 at one moment.
And who was responsible for serving Jessica and Morgan that night?
I served them both. I went to take their order on the rooftop a minute after they came in at 9.
And based on your personal observations, as well as your training, did Miss Marks or Mr. Levin seem obviously intoxicated?
No, Jessica seemed totally perfectly sober. Morgan was at the most buzzed and a little tired.
Did Jessica and Morgan order separately?
No, everything was on one tab, one receipt.
And would you recognize a copy of this receipt if I showed it to you?
Absolutely.
Your Honor, permission to display Exhibit 17 constructively outside the view of the jury.
Any objections?
No objection, Your Honor.
You may.
Thank you, Your Honor. For the record, we're now sharing Exhibit 17. Now, do you recognize this exhibit?
Yes, I do.
And do you believe this to be a fair and accurate copy of the receipt from that night?
Yes.
And to be clear, was this kept in the regular course of your business?
Yes.
Your Honor, at this time, we would move to admit Exhibit 17 into evidence.
Any objections?
Yes, Your Honor. I object to substantially more prejudicial than probative.
How so?
Your Honor, going through the pictures that Miss Levin took that night outlines the exact amount of drinks that Miss Marks had. What those pictures showed is that this receipt doesn't outline all the drinks that Ms. Marks had on the night of March 24th, 2019. Therefore, entering this receipt into evidence has substantial ability to mislead the jury into thinking that the drinks on this receipt are all the drinks that Ms. Marks had on the night of March 24th, 2019. Therefore, it's substantially more prejudicial than probative under Rule 403.
Ms. Beatty, anything?
Yes, Your Honor. If I may proffer for the court.
Yes, please.
We expect this witness to testify that all of the drinks listed on this receipt were the only drinks that she brought to Mr. Levin and Miss Marks that night. Specifically in regards to those pictures that were shown by the plaintiff, we believe that that would more go to the weight and not the admissibility of this evidence. We don't believe that it's more prejudicial than probative to simply show the receipt that was kept in the regular order of business. If the plaintiff wants to make an argument that free drinks were given out or drinks that were not to, of course, Ms. Maida's knowledge, then they can do so. However, Ms. Maida has already testified that all of the drinks listed on this receipt, or at least we expect her to, are the ones that she brought that night.
I'm going to overrule the objection for now.
Yes, Your Honor.
Thank you, Your Honor. For clarification, may this exhibit be admitted into evidence?
It may.
Thank you. Now, looking at Exhibit 17, is this an accurate reflection of all of the drinks that you brought to Miss Marks and Miss Levin that night?
Yes, all of the drinks from table 4 are on here.
And did anyone, other customers, your bartender, give them free drinks to your knowledge?
Not as far as I know.
And about how many times would you estimate that you visited that table that night?
maybe 8 to 10 times.
In your personal experience with owning a bar and serving alcohol to customers, have you encountered an obviously intoxicated person?
Yes, of course I have.
And are there signs that you look for in determining whether someone is obviously intoxicated?
Yes,
Could you list those signs for the jury?
sure. I look for things like red, watery eyes, vacant looks, and flushed cheeks, loss of balance, trouble with standing or coordination, slurring, loud or incoherent speech, or just being passed out.
And did Jessica Marks exhibit any of those symptoms over the course of that night?
No, her eyes weren't bloodshot, watering, or unfocused. She wasn't slurring her speech or being unusually loud. She didn't lose coordination at any time while she was at the table, and she sounded sober.
When Jessica Marks left your bar, was she exhibiting any of those symptoms that you mentioned earlier as being indications of an intoxicated person?
No, she did not look or sound obviously intoxicated.
And to be clear, if Jessica Marks or Morgan Levin had been obviously intoxicated, at least to your observations, would you have stopped them from drinking?
Of course,
And based on your observations, if either Miss Marks or Mr. Levin had been obviously intoxicated, would you have offered to call them an Uber, Lyft, or cab?
of course. I do that all the time with my customers. Neither of those two young women that night were obviously intoxicated.
Thank you, Your Honor. I have no further questions at this time.
Any cross-examination?
Yes, Your Honor. Just a moment while I prepare my camera setup.
You may.
May I proceed?
You may.
Ms. Mehta, as a bartender, people's lives are in your hands.
Yes,
You have the responsibility to cut someone off if they've had too much to drink.
yes, if they're obviously intoxicated, we can cut them off or call them an Uber, take their keys.
And like you mentioned, you're legally obligated to do that by the state of California.
Yes, if by my training I see that they are obviously intoxicated.
In fact, you go through a training course, like you said, to understand when someone might be obviously intoxicated.
Yes, of course, all my employees do so.
And in that training course, you'll learn about signs to look for to determine whether someone might have had too much to drink.
Yes,
And you mentioned some of those signs on direct examination.
correct.
One of those signs that you mentioned was someone talking loud.
Yes,
Another sign you mentioned was someone slurring their words.
also true.
And another one of those signs was someone talking incoherently. Would you agree?
Yes,
So if Ms. Marks had shown any of those symptoms to you, you surely would have cut her off.
of course, it's my legal duty to do so.
Well, permission to bring Exhibit 10 and show that video to the witness.
Okay.
Your
Your
Honor,
Honor, permission
if I
to
may
pause the
clarify.
time while we show this video so that constructively outside of the view of the jury, we can determine whether my opposing counsel wants to object to this video or on what ground she wants to object.
So it's my understanding that at this time, the plaintiff has asked that we hear this video. I assume we're going to hear now the audio on this video outside the presence of the jury. So for that purpose, we will view the video and we will go from there. I would like you to ask permission before showing it to the jurors.
Yes, Your Honor, of course. So we'll be showing that outside of the presence of the jury with the time stop right now.
Thank you.
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Mr. Long, what is your intention at this point?
Your Honor, my intention is to enter the sound and the video into evidence and show it to Miss Mehta and ask her a few questions about it.
Miss Beatty?
Yes, Your Honor. Specifically, we would still object to this being far more prejudicial than it is probative, specifically when we look at the nonverbal conduct of Ms. Marks in this video.
On that basis, I'm going to overrule the objection and allow it to be played.
Yes, Your Honor.
All right, now, Your Honor, we offer Exhibit 10 into evidence.
So entered.
And now we're gonna play that for Miss Mehta with the time going.
Hi everyone, Morgan and I are in Hollywood. We're in a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Now, Miss Mehta, you just watched all 37 seconds of that video, right?
Yes.
You saw how Miss Marks was acting in that video.
Yes.
And your lawyers agreed that this video was posted to Instagram at 11:11 p.m.
Correct.
You'd agree that in this video, Miss Marks appears that she could be intoxicated.
Well,
Objection,
I've been,
speculation.
Mr. Long?
Your Honor, we're not asking the witness to speculate as to Miss Marks's mindset in this case. We're asking her to form a rationally based perception of how Miss Marks is acting, as that is her job under the California state law to determine whether Miss Marks is displaying symptoms of intoxication.
As you just phrased the question, I'm going to sustain the objection. If you want to try it another way.
Yes, Your Honor. Ms. Mehta, Ms. Marks is exhibiting some symptoms of intoxication in this video.
I would re-raise my objection, Your Honor.
I'm going to sustain it again based on the way you just phrased it, Mr. Long. Try one more time.
Yes, Your Honor. Ms. Marks appears to be acting drunk. Is that right, Ms. Mehta?
Your Honor, once again, I would re-raise my objection as to speculation.
I'm going to sustain.
Yes, Your Honor. Ms. Marks is slurring her words in this video, is she not?
I've encountered a bunch of people who overly act drunk, so I'm not sure if this is proper slurring of words. And I wasn't there at the time.
Well, she calls a seltzer a spitzer, is that right?
Yes, but again, I've encountered a bunch of people, a bunch of customers that overly act drunk.
Well, she's talking pretty loudly in this video too.
Yes, there was music at my bar, the rooftop, and a bunch of people were talking loudly for me to hear them and take orders.
And she's also not making a lot of sense.
I don't see any incoherence.
Well, she says that everyone in LA wants to be a model or an actress. Is that right?
That's a common phrasing in California.
Well, she says, I'd like to thank the Academy. Mom and Dad, you've inspired me, doesn't she?
Your
That
Honor,
could-
I would object specifically to wasting the jury's time with this line of questioning and relevance.
Overruled.
So Ms. Mehta, she says, Mom and Dad, you've inspired me, doesn't she?
Yes, but this could simply be a joke.
Well, if you saw this video, you would have been concerned, wouldn't you?
Not really. My initial reaction was, oh, this is a joke, because again, I've seen a bunch of customers act overly drunk in my establishment.
Well, is it your testimony here today that if you saw this video, you wouldn't be concerned?
If these were true actions and I saw them for myself, then yes, I would take all the necessary precautions under state law.
So you surely wouldn't have served her more drinks.
No, if I saw these obvious signs of intoxication with my own eyes during the entirety of the 3 hours she was there, then I would take necessary precautions.
Well, let's bring exhibits 15, 16, and a screenshot from 10 with their stipulated timestamps up on the screen. Now, in this picture, you were going back and forth to their table all night.
Yes, about 8 to 10 times.
And in these pictures, a beer goes away.
Yes,
And a new one comes back.
yes,
And a glass with what appears to be rum and coke goes away.
yes, Jessica Marks made these orders.
And a new one comes back.
Yes,
So Miss Marks was served these drinks even when she was acting like this.
Mom and Dad, you've inspired me.
I was not there during the time. I was there 8 to 10 times at Miss Levin and Miss Marks's table, and I never witnessed any obvious signs of intoxication.
But Ms. Mehta, you still served her those drinks, didn't you?
Yes, because I felt no legal duty because she wasn't exhibiting any signs of intoxication.
So that's a yes to my question that you served her those drinks.
Yes, under the pretense that she was not acting this way when I was looking at her and when I was taking and delivering her orders.
Thank you, Ms. Mehta. No further questions, Your Honor.
Any redirect examination?
No redirect, Your Honor. However, I would like to make a clarification as to opposing counsel's demonstrative, specifically the timestamp for the video.
Okay.
Your Honor, I would simply like the record to reflect that while it is stipulated that all of those pictures shown were taken at the stipulated times, the video was posted to, I believe, Miss Marks's Instagram account at 11:11, but it is not stipulated or known when that video was recorded. I'd simply like the record to reflect that.
So reflected. Anything additional?
No, Your Honor.
Any further witnesses?
No, Your Honor. The defense rests.
All right. We will now move on to hearing closing arguments from each party. Before we move on, do either of you need a moment?
Yes, Your Honor. We'd like a few minutes to prepare for our closing argument, if that's possible.
Bailiff, is that something we can time out?
That is at your discretion, Your Honor. Yes.
Let's go ahead and, how are we on time? Can we do a 5-minute time break?
Sure. If that's what you like. Yeah, that's fine.
All right, let's go ahead and take a 5 minutes. By my count, that puts us back at about 4:03. So take your time and we'll be back up at that time.
Yes, Your Honor.
Yes, Your Honor.
Quick roll call from everyone. Quick roll call before we move on into closing arguments.
I could just ask both of the other scoring judges to confirm, excuse me, all three of the other scoring judges to confirm you're here. 3, 2, 3. All good.
Okay, well, then I hope that was adequate for the two of you. Mr. Long, we're going to go ahead and move into closing arguments. Everyone should please switch back to speaker view. Also, since both witnesses have completed their testimony, you can complete the witness portion of your ballot before we move into closing arguments. Mr. Long, you ready?
Yes, Your Honor, just a moment to set up my screen if that's all right.
Of course. When you're
May I
ready.
proceed? Yes, Your Honor. Members of the jury, Jessica Marks is a college student with such a bright future. In March of 2019, she took a trip across the country to visit her best friend right here in LA. On the final night of the trip, the two went to Sonny's rooftop bar to spend their last few hours together. Because the next morning, Ms. Marks was supposed to fly back home to her friends, to her parents. But the next day, when that plane flew out of LA, there was an empty seat on board. Because Ms. Marks didn't make that last plane home. Instead, she was flown back in the casket. Why? Why was this tragedy allowed to happen? Because the defendant saw the signs, but they just kept serving. Now, we, the plaintiff, have brought a wrongful death case against Sonny's rooftop bar under the California Dram Shop Act. To find the bar liable, we must prove two things to you more likely than not. First, that the bar served Miss Marks when she was obviously intoxicated. And second, that serving was a substantial factor in her death. Now, the judge in a moment is going to come before you and tell you about a term I just used. Obviously intoxicated. They're going to tell you a bit about what it means and give you some signs to look for to determine whether someone is obviously intoxicated. Things like red eyes, red cheeks, losing your balance, slurring your words, stuff like that. Let's go through how Ms. Marks exhibited those signs. Now, the defendant just kept serving. Now, you heard that Ms. Marks started the night off with a glass of wine at her Airbnb. You heard from Ms. Levin that this glass of wine was enough to have Ms. Marks acting drunk. She wasn't very big. She was only 5 feet tall, weighed about 115 pounds. The alcohol was hitting her. And that was before the defendant served her a single drink. But even though they saw those signs, they started serving. She started off the night with a bottle of wine. The defendant served her this bottle of wine. Now remember, that glass of wine was enough to have her acting drunk. But by the time the defendant served her, she'd had 5 times that glass of wine in her system. She was going to be intoxicated. Imagine what that one glass did to her and what 5 was going to do to her. The defendant claims she was perfectly sober. So they brought her another round. A can of beer and a White Claw. They served her these drinks. And by that point, she could hardly stand up. And that's exactly what happened. You heard that Miss Marks stumbled down the stairs and fell right into the arms of the bar's owner. You heard that they said, turned to their bartender, "We might need to cut this one off." But instead of cutting her off, they kept them coming. They served her another White Claw and a rum and coke. They put this alcohol into her system. They knew what it was going to do to her. And yet they claim She wasn't acting drunk at that point. Members of the jury, you see how much alcohol this is. And we're just getting started. After that, they served her a beer, another White Claw, and another rum and Coke. And you saw how she was acting at this point. You saw the video I showed you. They served her these drinks when she was acting like what Mr. Meenakshi Sundaram is going to bring up onto the screen. They served her those drinks when she was slurring her words, not making sense and talking loudly. They served her
Mom and Dad,
another rum and Coke.
you've inspired me.
Now, and after those drinks were served, after she was acting like that, after everything they gave to her, they had one last thing to give her on her way out the door. A shot to finish her off. Members of the jury, they saw the signs, but they just kept serving. Find them liable.
Thank you, Mr. Long. Ms. Beatty, are you prepared or do you need a moment?
We're prepared to proceed, Your Honor. However, I did want to make a clarification.
Please.
Yes, Your Honor. In regards to the demonstratives used in closing by opposing counsel, those were not shown to us before trial and were also not pre-approved. And we would object that that misleads the jury as to the fact that everything poured into that bucket was the specific amount and specific kind of alcohol consumed by Ms. Marks that night.
I will take your objection for the record. However, I am going to overrule it at this time.
Yes, Your Honor. Thank you. Your Honor, at this time, may we proceed with closing statements?
You may.
Thank you. May it please the court. She didn't have to drink. She didn't have to drive. She had other options, but she refused to take them. Members of the jury, the story of Jessica Marks's death is tragic, but tragedy should not guarantee liability for Sonny's Bar. Members of the jury, the plaintiff has had the burden of proof in today's trial. And in order for you to find my client liable, they must have proven to you by a preponderance of the evidence that the actions taken by Sonny's Rooftop Bar and its representatives so greatly impacted the course of Jessica Marks's night that they should be considered the most substantial and likely reason for her death. Now, the plaintiff has just come before you, and they said that those at Sonny's Bar saw the signs, and they just kept serving. And they asked you a question. The question that they asked was, why was this tragedy allowed to happen? And the answer, members of the jury, is not because of any actions taken by Sonny's Rooftop Bar, but the actions taken by Jessica Marks. Now, they also told you today that their responsibility was to prove to you that, one, they served an obviously intoxicated person, and two, that service was a substantial factor in her death. However, this isn't necessarily true. You see, there's one more thing that they have to prove. Members of the jury, the plaintiff has to prove that those at Sonny's Bar knew that Jessica Marks was obviously intoxicated, that she actively showed symptoms of obviously intoxication in front of Sonny Maida, who was serving Ms. Marks and Mr. Levin that night. They have to prove that Sonny's Bar knew. And I want you to consider everything that you've heard today. You've never heard Sonny Maida tell you that she was able to see any symptoms of obvious intoxication. You never heard Sonny Maida tell you that Ms. Marks had red, watery eyes, that she was slurring her speech. Even when shown the video, she explained that a lot of her customers play up for the video, that they act like they're having a great time. And you watched the video yourself. Nothing that Miss Marks said was unusual. Nothing that she said was out of the ordinary. This is important, members of the jury. I want to talk about Jessica's experience with alcohol. Today, you heard the testimony of Mr. Levin, and he explained to you that he didn't know Jessica Marks's drinking habits for a year prior to her death. And over winter break, he noticed that she had been drinking more than she had in high school. Her drinking habits had changed. And you're being asked today to apply Sonny's bar, the idea of obvious intoxication. And the fact that Jessica was drinking more, that she was more experienced, and that she was able to act less intoxicated is substantial. Despite the amount of alcohol that she had consumed that night, she was able to act not as intoxicated as Mr. Levin would have thought. This case all comes down, ladies and gentlemen, to what Sonny Maida was able to see that night. So think about what you heard today. You heard from Sonny Maida that Jessica was acting sober every single time she interacted with her. You heard from both parties that Miss Maida only had the opportunity to interact with Mr. Levin and Miss Marks around 8 to 10 times on that evening. Over the 2.5 hours that they were there, maybe 8 to 10 minutes. And you heard today that Jessica Marks had her keys in her hand, that she walked outside of that bar, that she faced the Uber that her friend had called because he was concerned. And she said, "I'll be fine." You heard today that Jessica Marks actively chose to drive home. No one forced her to. And in fact, she was presented with other options that would have been easier, that would have been safer, that if she had chosen, we wouldn't be in court today. It is undisputed that Jessica Marks made the decision to pull out her keys and drive. It is undisputed that Jessica Marks made the decision to drink at her Airbnb, to drive to Sonny's bar after already drinking once. It's undisputed that she walked into that bar and that she consumed alcohol. And it's undisputed that when she walked out of that bar, she was presented with a safer alternative and that she didn't take it. And we're not telling you, members of the jury, that this wasn't a tragedy, because losing the life of a 19-year-old young lady, that's a tragedy. And we don't want to make it any less so. But tragedy should not ensure liability for Sonny's rooftop bar, because it was Jessica who ultimately made the poor decision to drink, to drive home. And it was her negligence that resulted in this tragedy. Not any negligence, not any factors, not any action or inaction on the part of the defendant, my client. And it's for all these reasons that we would ask you find Sonny's rooftop bar not liable for the death of Jessica Marks. Thank you.
Will there be any rebuttal argument from the plaintiff?
Yes, Your Honor, we plan on giving a rebuttal.
When you're ready,
Yes, Your Honor. Just a moment while I set up.
of course.
May I proceed?
You may.
Members of the jury, Miss Beatty just told you that Miss Mehta didn't know that Miss Marks was intoxicated. I want you to think about that just a little bit. If Mr. Levin said that Miss Marks was drunk after just having this one glass of wine, then imagine how intoxicated she'd be after having all of this alcohol. That claim doesn't make sense. She says that she wasn't intoxicated, but you'll believe it when you see it. Members of the jury, Ms. Beatty also said that Ms. Marks made the decision to drive, but she also made that decision when the defendant had filled her with this much alcohol. That's not a decision she was making with a rational mind. Find the defendant liable for wrongful death.
All right. At this time, I'm going to ask that the judges please complete their ballots and click submit. I'm going to ask everyone to just stay put, hold tight until everyone submitted their ballots, and then we can do brief comments before we let you disappear. Sound good? All
Yes, Your
right,
Honor.
give us just a second.